Today, in this video, I'm going to kill the income tax in 20 minutes for all Americans. The Simple Truth About Income Tax by Thomas Freed, irszoom.com, and taxfreedom.com. Income tax. Today's income tax laws were originally enacted in 1913 and were almost immediately challenged in the courts. Those first income tax cases testing the constitutionality of the enacted laws were decided in 1916 by the Supreme Court. Now, while everyone in America seems to know that the income tax laws were determined by the Supreme Court to be legitimate and constitutional in those early challenges to the law, nobody knows why. So, just what did the Supreme Court really say about the income tax laws that it actually tested in those first income tax cases in 1916? Brushaber versus Union Pacific Railroad Company, volume 240, page 1. This is the first decision on income tax decided by the Supreme Court. It is one of the controlling decisions on the constitutionality of the income tax. In the very first sentence of the opinion of the decision, the court says, as a stockholder of the Union Pacific Railroad Company, the appellant filed his bill to enjoin the corporation from complying with the income tax provisions of the Tariff Act of October 3rd, 1913. The income tax provisions of the Tariff Act. Do you know what a tariff is? A tariff is a tax or schedule of rates for a tax imposed on foreign goods entering America or on foreign activity occurring here. But a tariff is not a tax that can ever be imposed on any domestic activity of the American citizens in the 50 states. I repeat, a tariff is a tax on foreign goods or activity that by definition is never imposed on the domestic activity of the American citizens in the 50 states. Is there any evidence of this allegedly foreign nature of the income tax as a tariff present in the income tax laws? Well, did the Supreme Court tell us anything else useful about the income tax legislation being tested in that Brushaber case? Yes, they did. The court tells us on page 21 of the decision, the Act provides for collecting the tax at the source. That is, makes it the duty of corporations, etc., to retain and pay the sum of the tax. Makes it the duty of corporations, etc., to retain and pay the sum of the tax. Does this say it is the duty of citizens to pay income tax on their own income by making a full disclosure of their own earnings on a tax return? No, it does not. It says, makes it the duty of corporations, etc., to retain and pay the sum of the tax. The Act provides for collecting the tax at the source. This duty of the corporations, etc., identified here by the Supreme Court to retain and pay the sum of the tax, was of course, and still is in fact, clearly defined in the law as the duty of the withholding agent. Title 26 United States Code, Section 7701A16 states, withholding agent. The term withholding agent means any person required to deduct and withhold any tax under the provisions of Sections 1441, 1442, 1443, or 1461. 4 code sections. Title 26 United States Code, Section 7701A, also defines the term person at subsection A1. The term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. So, under the law, who is it that withholding agents, the corporations, etc., are authorized and commanded to collect income tax from under the provisions of sections 1441, 1442, 1443, or 1461? 1441, withholding of tax on non-resident aliens. A, general rule, except as otherwise provided in subsection C, all persons in whatever capacity acting, having the control, receipt, custody, disposal, or payment of any of the items of income specified in subsection B, to the extent that any of such items constitutes gross income from sources within the United States, of any non-resident alien individual or of any foreign partnership, shall deduct and withhold from such items a tax equal to 30%. B, income items subject to tax. The items of income referred to in subsection A are interest, dividends, rent, salaries, wages, premiums, annuities, compensations, remunerations, emoluments, or other fixed or determinable annual or periodical gains, profit, and income, but only belonging to a non-resident alien individual. 1442, withholding of tax on foreign corporations. A, general rule. In the case of foreign corporations subject to taxation under this subtitle, there shall be deducted and withheld at the source in the same manner and on the same items of income as is provided in section 1441, a tax equal to 30% thereof. 1443, foreign tax-exempt organizations. Income subject to section 4948. In the case of income of a foreign organization subject to the tax, this chapter shall apply except that the deduction and withholding shall be at the rate of 4%. One should carefully note that the laws, by virtue of the code sections invoked in the definition of the withholding agent, sections 1441, 1442, 1443, and 1461, only authorize the withholding of income tax from foreign persons. And then remember that the Supreme Court said that the income tax of 1913 was part of a tariff act that by definition can only be imposed on foreign activity. And under the law, who is made liable by the statutes for the payment of the income tax? Section 1461, the last code section referenced in the definition of the withholding agent, liability for withheld tax. Every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax, and is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with the provisions of this chapter. This is the only statute in all of the income tax laws that make anyone liable for the payment of the federal income tax. This is the last code section referenced in the definition of the withholding agent. And it makes only the withholding agents liable as tax collectors for the payment of the tax that they have collected from other persons. By making only the withholding agents liable as tax collectors for the payment of tax that has been collected from other persons, the entire scheme of the income tax is kept indirect. So, just as a sales tax is collected and paid indirectly in the states by a tax collector in the form of a store that collects tax from its customers to be paid over to the state, under the actual enacted laws, the federal income tax is also collected and paid indirectly by a tax collector in the form of a withholding agent who collects the tariff from foreign persons by withholding money as tax from payments made to them. By injecting these third parties, the withholding agents, the corporations, etc., as federal tax collectors into the scheme for collection at the source, the burden to pay the income tax is shifted away from the payers of the tax collectors, and to the only true taxpayers under the law, the non-resident aliens and foreign corporations, the foreign persons that are the proper subjects of a tariff, and who are made subject to the withholding of tax by the statutes. In 1895, in Pollock v. Farmers Loan and Trust Company, the Supreme Court held that taxes paid primarily by persons who can shift the burden upon someone else are considered indirect taxes. Under the actual enacted federal income tax legislation that was tested and upheld by the Supreme Court in 1916, it is the third-party withholding agents who must pay the federal income tax, and they shift the burden of the tax they pay to the subject foreign persons by withholding money as tax from their payments. But withholding agents never pay tax on their own income, only on the income of the foreign persons from whom the taxes have been collected by withholding. And so we see that Congress, or the authors of the original income tax legislation, whoever they may be, actually very carefully crafted these income tax laws to be constitutional by writing the law specifically as they were instructed to write it by the Supreme Court in 1896 in the Pollock decision, by allowing for the shifting of the tax burden from the tax collector to the subject taxpayer. The true sovereign in America, we the people, are not the subjects of the federal government or the proper subjects of the income tax. The subjects are the foreign persons in the United States. We the people are the sovereign, the true owner, authority, and power in America. And the federal government is our servant, acting as our political representative, not our ruler. We the people are the masters. The federal government is our servant. The servant does not tax the master. Sovereigns collect tax. They don't pay. Sovereigns do not impose tax on themselves, but on their subjects. Sovereigns do not pay tax. They collect it from their subjects. Sovereigns collect tax. They don't pay. We, the people, the true sovereign, are not the intended subject taxpayers of this income tax. Under the enacted laws, we are the intended tax collectors. We are the withholding agents, the etc., and the corporations, etc. quote of the Supreme Court. You see, America was established as the first nation of kings, because in America it is we, the people, who are collectively the national sovereign. We all hold the power of the king, the sovereign. And the king doesn't pay tax, he collects it. No law taxes the domestic income of the citizen. We, the people, are the etc. in the Bruchaber quote cited earlier, and like the corporations, we, the people, have a duty to retain and pay the sum of the tax, or withhold tax from the subject foreign persons. However, this duty to pay tax over to the U.S. Treasury only relates to the taxes that we have withheld from other persons, the subject foreign parties. And who has to actually keep income tax records for the government? 6001, notice the regulations requiring record statements and special returns. Every person liable for any tax imposed by this title or for the collection thereof shall keep such records, render such statements, make such returns. The tax collectors keep records, i.e. the withholding agents. And who actually has to file tax returns? 6011, general requirement of returns, statement or list. A, general rule. When required by regulations prescribed by the Secretary, any person made liable for any tax imposed by this title or with respect to the collection thereof shall make a return or statement according to the forms and regulations. Again, it is the tax collectors who must file returns reporting the taxes that they have collected, i.e. the withholding agents. And that is the entire legal application of the federal income tax that is actually written in the law and was actually tested and upheld by the Supreme Court in 1916. Nothing else was tested by the Supreme Court. To summarize, the federal income tax is an indirect tax in the form of a tariff that is collected indirectly at the source by American citizens and corporations acting as federal tax collectors in the form of withholding agents who have an identified duty to collect the tax or to retain and pay the sum of the tax by withholding money as tax from payments made to foreign non-resident persons who are made subject by the provisions of the statutes in sections 1441 et sec. To the withholding of federal income tax from their payments, thereby effecting collection at the source. This shifting of the burden to pay the tax from the tax collector and to the underlying true subject taxpayer is a classic indication of an indirect tax that is laid, as a sales tax is laid in the states to be collected by the stores, in a manner that only authorizes the tax to be collected by the tax collector from specific persons involved in specific activities. And it is only the tax collector who is responsible and made liable for the payment to the Treasury of the tax that has been collected. It is the injection of this third party, the tax collector, who is actually made liable for the payment of the tax, that isolates the subject taxpayer from any contact with the government, making and keeping the whole taxing scheme indirect. Also keeping the tax indirect is the fact that a tariff is an impost, which is an indirect tax under Article 1, Section 8, Clause 1 of the United States Constitution, and which power to tax indirectly existed under the Constitution from the beginning. It has nothing to do with the 16th Amendment. This is why the Supreme Court said in the next case they decided, by the previous ruling, Bruce Shaver, it was settled that the provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. But no law taxes the domestic income of the American citizen. And American citizens are not required by law to pay a tariff, federal income tax, on their own domestic income. That would constitute direct taxation without apportionment, and that is still unconstitutional because the 16th Amendment conferred no new power. The provisions of Article 1 prohibiting direct taxation of the American people by the government have never been repealed or amended. We can still rely on their protections. Direct taxation of income is still unconstitutional. Finally, Do you know that a graduated income tax is the second plank of the Communist Manifesto? Do you really think the American government should be practicing communism today? So, let's kill this beast. Now, knowing the truth about the 1913 Tariff Act imposing income tax, wouldn't you also like to now learn the truth about your employer, Social Security, and the withholding of employment taxes under the provisions of the Current Tax Payment Act of 1943? Read the whole story at www.taxfreedom.com. Get affordable legal help at www.irszoom.com. Thank you.